very warm good afternoon to everyone. I am Chandrika Lamba from Business Outreach, from Lawyer Business Outreach Executive. I welcome you all to another session of Mentor Hour on comprehending property law and related disputes. Today we have a very special guest with us, Mr. Amit Srivastava, who is an advocate and founder of Legal Helping Hands. Before introducing our speaker, I would mention few points for the participants. I request all the participants to be on mute. I request all the participants that in a minute or so we will be sharing a link for the attendance. So I request all the participants to fill the form through the link. Third, I request all the participants to write their queries or questions regarding property law regarding today's topic. Amit sir will be taking those questions after the presentation. About Mr. Amit Srivastava, he is an alumnus faculty of law, DU, and works with AOR, Supreme Court, Senior Standing Counsel, handled independent cases since 2012. Initiated individual litigation practice in 2015. He has appeared in District Court of Delhi and other states, High Courts of Delhi and other states, National Companies Law Tribunal and Supreme Court. He has also worked on cases like check bounce, recovery suits, SAR, ESI Act and writ petitions. I would now request Mr. Amit sir to take over the screen and brief us about today's topic. Sir, sorry to interrupt, you are on mute.
Yeah, so am I audible to everyone?
Yes, sir, yes.
So warm welcome to everyone. Today we have a topic which is comprehending property law and its related disputes. Now, we all know that whatever...
Sorry to interrupt you, sir. Can you please share the PPT with the participants?
Yeah, sure.
Yeah. So that they
Alright,
can
so
relate to the topic.
yeah, so this is the disclaimer.
We are not able to see the PPT. I would request you to first share the screen and then you can select the presentation.
So is it visible now? This is the disclaimer.
We are not able to see the presentation. So what you have to do is, first you have to see below there is an option of share screen. Can you see that?
Share screen. Yes, ma'am.
Click on that and then select the presentation so that we can also see the presentation.
All right. So now we have this topic.
I request you full screen कर दीजिए sir from beginning and then we are good to go. Yeah.
Yeah. So that's a disclaimer. Should we move on to the next one?
Yes, sir.
All right. So today the topic deals with what all challenges we face while buying the property, or for that matter, while transferring the property. So what we need to keep into mind that whenever there will be any transfer of property, that would be governed by the provisions of Transfer of Property Act, which is year 1882. Now we see that Section 6 Property Act talks about what can be transferred. Now, if we read the section, it talks about that the Section 6 mentions what all properties, the immovable property and movable property is mentioned over there. However, the movable property has not been defined in the Transfer of Property Act anywhere. So the immovable property just about what all includes into the immovable property. So if we go through with the act, it would tell us that the property which is connected. Are we,
Yes,
ma'am, am I audible?
yes. If some
All right.
network issues are
So
there,
yeah, I don't know. Just allow me a moment, please. So we have section 3 of the act, which of General Clause Act, which would tell us that the immovable property, what does it not include, which is the standing timber, growing crops or grass. Definitely Clause Act 1897 is also not exhaustive. So we have a choice whether this property includes as a immovable property or not. We may note here that is also, so property it shall include and benefits to arise and things attached to earth. Does he find that while
Amit sir,
certain that include,
sorry,
yes?
sorry to interrupt you. I think there is a lot of issues with the internet, sir. Clearly, our audiences is not able to hear you properly. So if you can check the internet connectivity, maybe you can use some other
Just
network.
should we take a 5 minutes breather? I'll just have a look at it. Give me a moment, please.
I apologize to the participants. Sorry for the interruption. I request all the participants to be with us and please write your question or query in the chat box. Pracheta, the recording will be uploaded on the YouTube later. Also, we are going live on Facebook, so you can follow the page Lawyered and you can have this recording from there also. Amrit, this session is about on the property law. So, Mr. I request you to start your video and audio. Uh, I request you to unmute yourself.
Yes.
We can start with the first slide, I guess.
Yeah.
Okay.
So just give me. So is this PPT also visible to you, ma'am?
Yes, sir. You can choose the option from current slide so that everybody can see on this full screen.
All right.
Yes, sir.
I think it's Partition Act.
So we are
Should not
starting
go
with
here.
Partition Act.
No. We'll begin with this oral transfer.
So you can change the slides to right and left
Let me make it
partition.
a full screen, ma'am. Or we
No,
can
Amit, we
look at
are
this.
in the session itself. So I think sir has some network
So
issue.
is it visible?
Yes,
The
sir.
PPT is still there? All right. So now we will, as we have discussed earlier, that there are two kind of properties, which is movable and immovable property. Now, immovable property does talk about, so the General Clause Act Section 3 to Section 3 subclause 26 enumerates certain property which are not immovable property. So if there is a property which is standing timber, or so that would be not a immovable property. And then we have certain other things which are also mentioned, which would be the crops, standing crops and the grass. So these are not going to be included as the immovable property. Now the movable property is mentioned in General Clause Act that as anything which is not immovable property would be taken up as a movable property. Now, so the law which talks over here, we are onto this, that Section 6 of Transfer of Property Act talks about that which property we can, how we can sell the like property. So what is a mode to transfer the property? So the transfer has to happen between the living persons. It has to be either the immovable property or movable property, and the certain other features which are also mentioned over there. We can have a look at the Section 5 of TP Act also. This talk about the which Transfer of Property Act, which is a living person convey property in present or in future to one or a living person. So the transfer of property is is to be between the inter vivos. So that means the living persons. Now, over here, Section 5 also includes any person or any company or an association or a body of individual. We all know that company is an artificial person. So even the property can be transferred, alienated in the favor of a company, or for that matter, a body of persons as well. Now, the question that arises, what kind of property or cannot be transferred? Now, the Act does not specify what all property can be specified exactly in the exhaustive manner, but it does talk about what all cannot be transferred. So Section 6 of the property says that what can be transferred except if it states otherwise. So if there is a particular act which has put a bar on to transfer of certain property, which would be either the state amendment or anything of that sort, that can very well be taken into consideration. So any kind of except if a state otherwise of the act, which essentially makes its exhaustive list. So it is the state which has to make exhaustive list of the property details which cannot be transferred. Now we are on to the section 9, which is oral transfer. Now there are properties which can be transferred orally also between the transferor and transferee. What will happen that if we have transferred the property, one needs to consider that any property which is of having a value less than 100 can be only transferred, which is not possible nowadays. But at the time of beginning of this act, this has been brought into picture. So at that point of time, the value of 100 was uh, much better as compared to today. Now we do notice that the with the flux of recent judgments, we have seen the Suraj Lamp judgment also in 2008. Supreme Court's passed judgment wherein it is categorically mentioned that the property needs to be registered. Now, section 53 of 53A of Transfer of Property Act talks about the part performance if certain party complies. Like let's assume uh, a property is transferred between A and B performs certain condition, and even if so the agreements imports, so whatever obligations are mentioned into the agreement is fulfilled by the transferee, then that property can be transferred. Nevertheless, the property has not been registered as per the Indian Registration Act, then also the property can be transferred and the possession of the transferee would deem to be legal one. Now we have a section 54 of Transfer of Property Act, which would talk about the sale pertaining to the Transfer of Property Act. Now, if we look at it, just
Sorry to interrupt you, sir. Yashika has asked to repeat the judgment name.
that's Suraj Lamp. That's also mentioned in the slide. Let me show you. So that's Suraj Lamp Industries versus State of Haryana and others. Well, this judgment talked about that there are some unscrupulous buyers. What they do, they buy the property, they don't disclose it to the regulating authorities. So the government is not getting benefit pertaining to the Stamp Act, or for that matter, the tax is evaded by those people. So the black money was getting more generated out of it. So that is why, just to put a check on it, this judgment has brought into has been passed by the Supreme Court, wherein it categorically held that any property which has been transferred has to have registered. And it also reminds us that in 2001 Indian Registration Act got also amended to the same effect, wherein if the property has not been registered, it does lose its essence. Now, one thing needs to be looked into this judgment, that the property which are sold through general power of attorney, if the property, if the transferee is in possession and there seems to be no disturbance to his possession, then in that situation, that possession is very well still protected by virtue of section 53A of Transfer of Property Act also. Now, should we just move on to the
Yes, sir.
section 9? All right, so section 9 talks about the oral transfer. As we have seen that there are certain properties which have been transferred earlier prior to this judgment through GPA as well. And see, if there is particular family member, he or she is transferring the property in the favor of his son by virtue of either the family settlement, then that is not necessarily to be recorded into the writing of that matter, it has to be registered. If we there is a judgment which I would like to quote here. Just a moment. Just give me a moment. All right, so there is this judgment of Sarandya Pillai versus Sankarlinga Pillai, which is pertaining to the year. So that is
So can we proceed further?
yeah. A few things just we had to mention over here pertain to the oral transfer. Some properties which are transferred through family arrangement or family settlement, that does have its validity even if it being orally transferred. So this would talk about, so as we have discussed that there was a sale of immovable property of value of rupees 100 or upwards, that has to be registered, and obviously there the agreement has to be there, the written agreement. Now let's assume if there is a simple mortgage, the simple mortgage is there, we are just depositing the title deeds. That does not mean every like every now you have to get the written agreement also entered between the mortgagee and mortgager. Should we just, and then we have the condition of oral gift. Even the oral gift did not require it to have it written, mentioned it in written. All right, so let's just get back onto our presentation topic. Okay, now next is condition restraining alienation. So let's assume if the property is being transferred in the favor of transferee, and and there is a particular restriction put onto it pertain to the transfer. So let's assume if the transferee has got the property and he is being restricted as per the transfer between the transferee and transferor, that he cannot further sell it to some person, or there is a particular way he has to sell it. So those conditions are going to be taken up as it was not mentioned earlier. So these conditions will not hold any significance. Now there are, we know that there are two kinds of property as we have already seen it, that is pertain to the title of immovable property. So there is a particular property which has been sold, and there are number of people who have purchased the property because the transferor has sold it through GPA, general power of attorney. Now what he did, that he sold it in the favor of one person, and while concealing this fact he sold it to the another person. So there the question arises, this whose right is going to be protected. Now one needs to look at it that the subsequent buyer was supposed to have the due diligence carried out in to ensure that the property is free from all encumbrances and charge. Now if this if the A property which has been purchased by the uh, subsequent purchaser, he was supposed to keep into his contemplation that it was not purchased by any other person, though it does talk about the rights of it talks about the uh, fraudulent activity of the transferor as well, because he has concealed this fact, so he should face the wrath of law in this regard. Now the first purchaser who has bought this property will be protected in that situation, so his right is going to be protected. Now so this kind of situation arises where the properties are not getting registered, either because there is no such enactment to cover those property, the way we have Land Abadi Act 1912. So there are properties lying situated in Humayunpur and many other places which are which was initially to be agricultural land, but subsequently with the passage of time that property was held by the landowners. Now they converted in the agricultural property into the uh, what do you call that, into the residential property, and there still the registration of property was not happening, because as such there was not particular statute to look into it. However, ever since the Suraj Lamp judgment has come, the government is also trying to ensure that those places which had no registrar to look at it, because it being an unauthorized area, are getting also covered as an authorized area, so that those property could come into the ambit of registered properties. So there is first dispute. We talked about the title of immovable property. There could be other cases as well. Let's assume if there is already a charge created onto the particular property, so the transferor has taken a loan from someone, and without mentioning it to the purchaser of the property, he has sold that property to the purchaser. So he had actually concealed the fact about the charge being created onto that property. So in that situation also, the uh, charge which has already been created by the bank or any of that authority will hold the property, will can attach the property, and that sale is going to be termed as a void or invalid. So the second head of the dispute which we mentioned here is disputes relating to inherited property. Now let's assume there is a particular A property that has been sold, sorry, that has been transferred into the favor of one particular legal heir named B by his father, who is A, as wide will, with wider will, or which is a non-testamentary disposition. So that will does not require that it would be registered. So let's assume if the will has already been what do you call that, written in the favor of B legal heir by the by his father, so that will only take effect once A will die. Now if the A was in fit condition of fit condition fitness, or of condition of mind, or for that matter he was not suffered from any infirmities, in that situation this will can be termed as a legal one. And once that property has been bequeathed through will into the favor of B, he does not require it to be probated in Delhi. So there are different states wherein the will are required to be probated also. When we say probated, that means the uh, person in whose favor the will has been executed, he needs to go to the tehsildar and get that property, get that will mutated in his favor, thereafter only it would be termed as that the will has got its attained its finality. However, in Delhi, it's a different situation. Over here, if the will has already been uh, written in the executed in the favor of particular legal hair, and even if the other legal has an objection to it, they may approach to the courts pertaining to it. But what will happen, that his will still hold the legality. I hope it makes sense. All right, so now we have so there is another, so section 10, we had this condition restraining alienation, we have already done. Restriction repugnant to the interest created. Now sometimes what happens, that there is a particular property, it has been transferred in the favor of transferee. Now there could be someone who's residing next to the transferee, so any other person will not be restricted from enjoying to the common way of the property, or for that matter the property which is into the which is not restricted. So I mean to say that, let's assume there is particular person B, he has bought a property. Now C, who resides next to his house, if there is a proper there's a particular stair which is there, so C cannot be restrained from enjoying that property, and that restriction can be there upon to the transferee, that he will not restrain the any third person from enjoying any of the common ownership of the property. Now we also have the restriction. When we talk about the restriction repugnant to the interest created, it also says that, let's assume there is a particular property which has been sold. Now it is mentioned over there that this property is to be kept by the transferee for a particular time period. Thereafter, it would devolve in the favor of the legal heirs of the transferor. So it cannot happen. So that would be termed as a void. Of that matter, the restrictions is going to be termed as a repugnant and will not hold any significance onto that property. So the transfer is would be deemed as a valid one. Subsequently, we have a condition making interest determinable. All right, just keep it. All right, so in section 12, we have a condition making interest determinable on insolvency or attempted alienation. Now, let's assume the transferee has bought a property from the transferor and he has now become insolvent. In that situation, it does not mean that once he has become insolvent, this property will go back to the transferor or his legal heir. What he can do, that he will still hold the let's assume even if he is insolvent, he will hold the ownership of that particular property which he has uh, which he has been transferred. Now let me just quote you as an example onto it. Just so
So you are we
all right,
getting?
so just give, yeah, yes ma'am, tell me.
Are you trying to go on the like web search, or you want
I just
your?
wanted to mention about certain. We'll take another 10 minutes and we'll finish it off. Ma'am, So we have in section 10, as we discussed earlier, where it talks about where a property is transferred subject to a condition or limitation absolutely restraining the transferee or any person claiming under him from parting with or disposing of his interest in the property. The condition or limitation is void except in the case of lease, where the condition for the benefit of the leaser or those claiming under him provided that a property may be transferred for the benefit of women. Now, as we have seen that we have already discussed about section 10, that a property once transferred subject to a particular condition or limitation attached onto the or imposed upon to the transferee or any other person, like let's assume is a legal hire or assignees, then in that situation from parting with or how he would dispose of the property, such limitation is going to be void except the case of lease where the condition is for the benefit of the leaser. Now let's assume there is a property which has been transferred through lease in the favor of leasee. There the leaser has specifically mentioned that if you are going to transfer it to so and so person, that cannot happen. You need to either transfer it within your family, the way we have when we, let's assume we got a property from the municipal authority, also we buy the property from the DD also. Therein also this covenant holds its import that if we have bought the property before selling it to anyone out of legal like apart from our family members, we need to get the property mutated. Thereafter only we would be able to transfer it into the favor of any person who is uh, apart from their family member. So any third person, I must say over here. So all right, so there is a partial restraint which is mentioned here, a restriction for a particular time or a particular. So there are two kind of restraint mentioned here. One is a partial restraint. A restraint for a particular time or a particular specified person has been held to be an absolute restriction. So the compromise by way of settlement of a family dispute has been held to be valid. Let's assume if there is a restriction being placed that if you would be selling this property to anyone, to third party or anyone who is not a family member, then it would the property would turn back to, then the property will be first asked to the family member to purchase it, then that restriction is valid one. So the property which we try to ensure that it would remain into the family can still hold its significance. Generally what happens that whenever there is a property which a third party purchases, or there's a particular share which a third party purchases from one of a legal hire of the property, then he will not be able to take possession of the dwelling house of the property, because there are other legal hires who are enjoying, who are into the enjoyment of that property in a common manner. So there what will happen that such transfer is going to be termed as invalid, or for that matter this that particular transfer, so particular transaction, if the transferee buys the share, he may either give it back to the other legal hires as well. Now we have the section 11 already we are taken care of. Section 12, we had this where a property is transferred subject to the condition or limitation making an interest therein reserved or given to or for the benefit of any person to seize on becoming insolvent or trying to transfer or dispose of the same, such condition limitation is void. Nothing in this section applies to condition in lease for the benefit of the leaser or those claiming under him. So if there is a particular property which has been transferred, as we know that just being an insolvent of the transferee will not let the property be transferred back to the transferee. Ma'am, are we still having some time?
So we have implementary rights and remedies. I think we
Yeah, we'll just
proceed
go
to
through
next
with
slide.
section 13 and 14, and then we'll finish it off with these particular sections. So transfer of benefit of unborn person. Section 13 talks about transfer of for benefit of unborn person, whereon a transfer of property and interest therein is created for the benefit of person not in existence at the date of transfer, subject to prior interest created by the same transfer. The interest created for the benefit of such person shall not take effect unless it extends to the whole of remaining interest of the transferor. So, for example, a transfer of property which is the owner to be in trust for A and his intended wife successively for their lives, and after the death of the survivor for the eldest son of the intended marriage. So let's assume there is a particular property which has been transferred. There is an interest which is created for the benefit of person which is not in existence at the date. When we say a person who's not in existence at the date of transfer, that means an unborn child, subject to prior interest created by the same transfer. So if there is, or for that matter, even a person who is deceased, so if there is a interest already been created, prior interest created by the same transfer, the interest created for the benefit of such person shall not take effect. So let's assume there is a particular property. He has been, it has, I'm sorry, it has been sold in the favor of C. Now there is a particular person B who has died. Now if B has died, his legal heirs will have the interest created in that property. So that's what the example talks about here. A transfer for which is the owner to be, A transfers property for which, so A transfer, A has transferred the property for which he is the owner to be in trust for A. So for the property which is A, he is the owner, not in his sole capacity but as on to the trustee, and he is intended wife successfully for their lives, and after the death of survivor for the eldest son of the intended marriage for life, and after his death for A's second son, the interest so created for the benefit of eldest son does not take effect because it does not extend to the whole of A's remaining interest in the property. So whatever interest has been created, that needs to be looked at, that the whole interest in the property needs to be created. We have the case law
I
here.
request you,
You made, yeah,
can we like proceed forward to next slide?
I'm sorry ma'am. All right ma'am, we'll just,
No, no, not an issue, sir. We have questions also lined up. So I request you if you can just
there was only
request
one
you.
section which was left, section 14. If
I
should I
think
just finish it off with?
because the rest of these slides we haven't seen them yet. We are stuck on
All right,
section
sure ma'am.
2.
Sure ma'am, sure.
You can use from current slide, and then you can use right button.
All right, sure ma'am, I'll do
Right.
it. All right, we have, so as we are on to this section 9 to 15, is it visible ma'am?
Yes, yes.
Yeah, so we have section 14 of Transfer of Property Act. So it talks about that no transfer of property can operate to create an interest which is to take effect after the lifetime of one or more person living at the date of such transfer. So if there is a transfer which has happened, no, it cannot take the create an interest which is to take effect after the lifetime. So if there is an a person, if he has died, so the property in his favor would obviously be devolved into the favor of his legal heirs. over here, it is a rule against the perpetuity. No transfer of property can operate to create an interest in which is to take effect after the lifetime of one or more persons living at the date of such transfer, and the minority of some person who shall be in existence at the expiration of that period, who shall be in existence at the expiration of that, and to whom, if he attains full age, the interest created. So let's assume there is a particular property that has been transferred. Now at that point of time, the particular person is minor, so there the rule against perpetuity law comes into picture. It will hold its value as that the transfer which has been affected into the favor of particular person, that transfer will be considered as a genuine one if it will be in the favor, it will be uh, in the favor of the, what do you call that, minor person. So a covenant for preemption does not offend the rule against the perpetuity and cannot be considered valid. All right, let me explain it with the, I may need to just go through with the particular judgment onto it. If you allow me, I'll just. So over here we have a particular judgment of Sundar Rajan versus Nat Raja, which is the Privy Council held that since at the date of transfer, it is not known whether or not a guardian would be appointed by the court for the minor in future. For purpose of section 14, the normal period of minority would be 18 years. Let's assume there is a particular property which has been sold, which actually belonged to a minor person, so that his interest is there, but it has been sold by his guardian. Now, so the vesting may be postponed up to the life of the last person holding and the, all right, so if so this vesting will be only till the time he that person is a minor. So there is a particular person who's holding the property. For that minor, he will held the property only till 18, subsequent till the minor turns out to be major, or for that matter 18 years old. Once he turns to be 18 years old, the property would devolve in the favor of that minor. Now we have a section 15 which talks about the transfer to class, some of whom comes under section 13 and 14. If on a transfer of property, an interest therein created for the benefit of class of persons with regard to some of whom such interest fails by reason of the rules contained in section 13 and 14, such interest fails in this regard to those person only and in regard to. So if there, as we have discussed that there is a particular interest being created in the favor of unborn person, and there are so in section 14 we did talk about that the, if there's a particular property which has been transferred in the favor of minor, of that matter deceased person, so whosoever is looking at the property as a trustee, or for that matter the guardian would hold, will be able to hold the property only till that person turns out to be major, or for that matter the legal hire of the deceased person would be capable to manage the property. So over here, section 15 talks about the class of such persons. Over here, there is a judgment of Raja Bajrang Bahadur Singh versus Thakuran Bakhtar Raj Kaur. Supreme Court held that the amendment of 1929, where an interest is created for the benefit of a class of a person, with regard to some of whom such interests fail on account of the rule against perpetuity, such interests fail in regard to those person only and not in regard to the whole class. So if there is a particular person who whose property has been transferred, he has died and he had actually transferred in the favor of some xyz person, so it is only his share which would be deemed as to be transferred. The whole property, the interest would not be created onto the whole property. So should we just move on to the partition act? All right, so we
So,
have
sir,
a.
we are on, from participants' point of view, we are able to see section 2 to 7. So, I request you to coordinate with the slide and the topic you are mentioning.
I'm sorry, ma'am. What was that?
So, we are able to see section 2 to 7 wala slide, which is, I think, 7th slide from your
This is
presentation.
what we are doing right now.
Okay. So, are we moving to partition now?
Yeah, we are moving to the partition.
Okay.
So, part of a code to order sale instead of division property. Let's assume there are certain properties which are not able to be determined by meets and bounds. As we all know that whenever the property has to be partitioned, it has to be done by meets and bounds, and the court is unable to determine it. So there the property can be ordered to be sale also. Now the first option would be that the legal heirs will be I'm sorry, the co-sharers in whose favor the property devolves needs to sort out that if any one of them is going to buy the property, or for that matter just to ensure that the essence of the property be maintained, because that was for the common enjoyment of the property. And there may be so as the partition act is brought into picture just to ensure that the property, the last resort to sell the property would be to third person. Otherwise the options are going to be explored between the family members itself, or for that matter the co-sharers in among themselves. So over here, part of a court to order sale instead of division in partition suit, we have. All right, so let me read the verbatim to it. So whenever any suit for partition in which, if instituted prior to the commencement of this act, so when the act has brought in has come into existence prior to this, if the any partition suit has been filed, a decree for partition might have been made. It appears to the court that by reason of nature of the property to which the suit relates, or the number of shareholders therein, or any other special circumstance, a division of property cannot be reasonable. So as we have discussed, that the property is not able to be like not divided reasonably or conveniently be made, then a sale of the property and distribution of the proceeds would be more beneficial. So when we talk about the property would be either distributed by the meets and bounds, and the proceed means the sale proceeds, or for that matter the let's assume if a particular shareholder is willing to sell his share in the favor of other co-sharer, so he may take the consideration against to it. So that can also be taken care of. Now over here it talks about that would be more beneficial for all the shareholders. The court may, if it thinks fit on the request, so if there is any particular shareholder, he says that this property interested individually or collectively. So if particular shareholder approaches to the court and says that I am willing to buy the property, interested individually or collectively to the extent of moiety or upward, direct a sale of the property and distribution of. So that property can be sold off in the favor of that particular person also, and the whatever sale proceeds are there, that would be distributed among all the shareholders equally, as mentioned into the particular judgment talking about its all right. So section 3, which talks about procedure where sharer undertakes to buy. So as we have discussed earlier, so the partition decree has been passed. Thereafter the court is on to the procedure where how the sharer undertakes to buy, how he will be buying the share. So as we know, there are two ways: either the preferential share purchase. So let's assume if the particular shareholder approaches to the court and says that I am willing to buy it, so that will be taken up as a preferential sharer. And so over here, let me explain on to this. If any case in which the court is requested under the last foregoing section to direct a sale, so as per section 2, if the court has ordered that sale has to take place after the particular property, or any other shareholder applies, and there is particular shareholder who applies for the court's leave to buy at a valuation. So if there's a particular shareholder, he applies to the court for a permission to buy at the valuation the share or shares of the party, or party is asking for a sale, the court shall order. So if there's a particular shareholder, he says that I want to buy this like entire property or this particular share also, so that share would be valued. So there would be a valuation of share which will take place, and it may think fit and offer to the sale the same to such shareholder at the price or certain. So whatever price would be a certain wide valuation will be sold to the shareholder at that price, and may give all necessary and proper directions in this behalf. So we have certain conditions laid down here, which is if two or more shareholders apply severely apply for a leave to buy provided in subsection 1, the court shall order a sale of the share or shares to the shareholder who offered to pay the highest price. So let's assume there are two shareholders. One of both of them says that we are willing to buy the property. Now what needs to be seen here? Whoever is the highest bidder will be a higher bidder to buy that share, will would be able to buy that property at that valuation, at that price. So as we say, the applicant or applicant shall be liable to pay all cost or incident to the application. So whatever application we move to the court, and to facilitate the sale of particular share, of for the matter bidding of that particular share also, that would be all the costs will be borne by the sharers among themselves. So whosoever applied for it. Now section 4 would be partition suit by transferee of a share in a dwelling house, where a share of a dwelling house belonging to an undivided family. So there is a particular property which belongs to undivided family has been transferred to a person who's not a member of such a family. So here it talks about the third party, so the outsider, and such transferee sue for partition. Now the outsider has sued for the partition to the remaining shareholders. The court shall, if any member of the family being a shareholder shall undertake to buy the share of such transferee, make a valuation of such share in such manner as it think fit, and direct the sale of such share to the shareholder. So if there is a particular shareholder who's also a legal hire, what will happen that if he has approached to the court can allow him to buy the shares of such transferee and make the valuation, and then he can make a payment to him of that sort also, and direct the sale of such share to shareholder, and may give all necessary and proper direction in any described two or more. So similarly, now just to ensure that over here the shareholder will be, are we onto this page? So ma'am, now the next section is representation of parties under disability. In any suit for partition, a request for sale may be made or an undertaking. I hope that, all right. So we are onto the section 5, which is the representation of parties under disability. All right. Okay, so in any suit for partition, a request for sale may be made, or an undertaking or an application for leave to buy may be given or made in behalf of any parties under disability. So there, this talks about how the disabled persons are to be represented after in the partition of suit. If there's a particular property, once the decree for partition has taken place, now when the actual partition will take place, the interest of the disabled persons will have to be protected as well. So this section would talk about it. So here it says that in any section, suit for partition, a request for sale. So there is a particular request has been made to the court for sale or undertaking an application for leave to buy may be given on behalf of any party under disability. So there is a particular person who's disabled, and if there's an application being moved by one of a shareholder, so to buy his property, disabled by any person, are authorized to act on behalf of such party in such suit, but the court shall not be bound to comply with such request undertaking application unless it is of opinion that the sale or purchase will be for the benefit of the party under such disability. So if there is a particular shareholder who is disabled and his representation has to be made, there's a person who's authorized on his behalf is looking at it. So now the court is not always there to accede to the request. Court will look at the option whether the sale or purchase will be beneficial for the party under the disability or not. Not like the previous sections where once we have applied for it, court may have a discretion. If we have a bona fide, court would allow it. But over here, court would also give greater import to the disabled person's rights. Now we have a section 6 which talks about reserve bidding and bidding by shareholders. Now every sale under section 2 shall be subject to reserve bidding. We know that section 2 of the transfer of partition act talked about once the decree for partition has already been passed, thereafter the if the court orders sale. Now in section 6 it says that every sale under section 2 shall be subject to reserve bidding, and the amount of such bidding shall be fixed by the court in such manner as it may think fit and may change from time to time. So the court will fix what is the minimum bidding price for a particular share into the property, and that can obviously vary by the court in itself. On any such sale, any of the shareholders shall be at liberty to bid at the sale of such terms as to non-payment of deposit, or as to setting off or accounting for the purchase money or any part thereof, instead of paying the same as to the court may seem reasonable. So let's assume on any such sale, any of the shareholders, so shareholders will be at liberty to bid at the sale on such terms as the non-payment of, so if they don't deposit a particular payment, then also they'll be able to bid for the particular share as to setting off of the account. So here the court has put it onto the exception that that does not mean that the minimum deposit value will have to be a deposit that would be inter se the shareholders. Now here in third clause it talks about if two or more persons of whom one is shareholder in the property respectively advance the same sum at a bidding at such sale, such bidding shall be deemed to be bidding of the shareholder. So there are two or more persons for the bidding onto the particular property. One of the shareholder, he respectively advances the same sum at the bidding. So at the time of bidding, he has given the same amount. Such bidding shall be deemed to be, so it would be taken up as the bidding of that particular shareholder. So if he gives certain amount in that situation. Now we come on to the section 7, which talks about procedure to be followed in cases of sale. So if as herein before provided, so whatever is mentioned in the prior sections of the Partition Act will have its validity. Apart from that, when any property is directed to be sold under this act, so if there is any other property which has to be sold under Partitions Act, the following procedure shall as far as practicable be adopted. Namely, if the property to be sold under a decree, so if there is a particular decree of the court or order of the High Court of Kolkata, Madras or Bombay in the exercise of its original jurisdiction, so there is a particular High Court prior to the changes or the modifications made in the act, the High Court has been set up by the British government were into it, so to look at the partition of the property. So they used to have the original jurisdiction.
I am sorry, participants. I think there is a technical problem. I request all the participants to be there, and so will be joining in a minute or so. I just had a word with sir. I think there is a electricity issue, so he'll be joining with us in another 2 minutes. So I request all the participants to be with us. He'll be covering up Benami property and one more section, and then we'll be taking the questions. Till the time, I request all the participants to fill up the attendance form. If you have not filled the attendance form, do let me know in the chat box, or any issue you are facing while filling the form. Just spoke to sir. I think there is a power cut at his place, so he's not able to join the webinar for the time being. So I request all the participants who have dropped their questions. So I request you to drop these questions either to sir. In the presentation also he has shared his email address, or you can write it to partnerus@lawyer.in. So we'll be happy to provide a solution to your queries. So I request Ashutosh. I can see a person joins through Vivo 1807, and Samiksha, Amulya, I think Yashika. So I request all the participants who have write their questions. I request you to write it on the through email, which I just mentioned. Thank you everyone for joining us today, and thank you for your patience. I would like to thank lawyers. So maybe in another upcoming session, we'll be taking up a mentor hour on property law. Also, we have a webinar tomorrow on startup. So I request all the participants who are interested, please do join us there. Thank you. Have a good evening.